The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good afternoon and welcome to the Kansas Supreme Court. We have two cases on the afternoon docket. I would ask Mr. Doug Shima, the clerk of the appellate court, to please call those cases.
Thank you, Your Honor. May it please the court. The 1:30 p.m. docket for Friday, May 28th, 2021 consists of two cases. First case is appeal number 121105, State of Kansas versus Tria L. Evans, Douglas County, briefs both sides. The second case immediately following will be appeal number 123682 in the matter of Roy T. Artman, original action and attorney discipline. Your Honor, the appellant in State v. Evans has reserved 3 minutes rebuttal time. We are ready to proceed.
Thank you, Mr. Shima. Counsel, would you please enter your appearances?
Good afternoon, Your Honors. Corinne Genning from the Appellate Defender Office appears on behalf of Appellant Tria Evans.
Good afternoon, Your Honors. Appellee, the State of Kansas, appears by Assistant District Attorney John Simpson.
Thank you, counsel. Ms. Genning, you may begin your argument.
Just a brief background on how we got where we are. The state charged Tria with the killing of Joel Wales, along with conspiracy to commit the murder and arson based on entirely circumstantial evidence. She was convicted after a 5-day jury trial of all those counts based in part on evidence that was challenged as inadmissible hearsay and evidence of prior crimes. She requested before sentencing a mental health evaluation pursuant to statute, which the court denied, and ultimately also denied her request for departure sentencing and imposed a hard 50 sentence. In this case, I have briefed 3 issues, which I am prepared to discuss as the court directs, but I plan to begin on the mental health evaluation issue and then move to the hearsay issue and submit the 6455 issue on the briefs. So beginning with the mental health evaluation, this court reviews reviews the question of a decision related to KSA 223429 for an abuse of discretion. And counsel maintains that the court in this case abused its discretion based on an error of law.
Can you tell me what you did not what you, but what trial counsel did to make the request? As I reviewed the record, it was just a request pursuant to statute without anything further substantiating the basis for the request. It was just a request. Am I right?
I believe that is correct. Yes.
Okay, so go ahead and tell us why that was an abuse of discretion when there was no other reasoning provided to the court to order the evaluation.
I guess I would compare it to how this court views competency evaluations. Now, I understand that they are different requests, different purposes, different things that they're trying to preserve. But for competency evaluations for the pretrial competency, the court, this doesn't require a showing of why an evaluation is needed. It has long simply deferred to defense counsel. Defense counsel knows their client the best. And obviously, defense counsel in this case believed that there was some reason why a mental health evaluation for sentencing purposes would be appropriate and best serve her client. So I don't think that there's any requirement that counsel make a showing of why she believes that is why a mental health evaluation is required. It's up to the discretion of the court to grant it to grant or deny it as they wish once it's filed. But I don't think that there's a requirement to say why.
Was the purpose of this evaluation because there was a question of whether she had lost competency to continue the criminal prosecution, or was it because the evaluation was sought for evidentiary mitigation purposes? And if they're different, does that make a difference? If it's not competency, does that make a difference?
Certainly, it probably does make a difference, just because of the constitutional protections against convicting and sentencing someone who is incompetent to understand the proceedings. But what our legislature has created is a mechanism for presenting mitigating evidence, so that the court can make a determination of where the client might best be served once they are sentenced. And so if they have a mental health, a mental illness that deserves treatment and that should be treated, and that serving their sentence in a mental health facility would material aid in their rehabilitation, that's what this statute provides. And so certainly it is different than a competency evaluation, but it is something that our state has said that is available and should be considered. And in fact, the court in U.S. v. Kaler indicated that the change in the mental disease and defect statute that happened in Kansas does not affect requesting mitigation at sentencing. And so that this is still something that is protected for the client to request if they have a mental illness that needs to be treated and would be better treated outside of a prison setting.
So it's your position, basically, all it takes is a request and the court has no discretion whether to grant or deny the evaluation.
I suppose I would disagree with that interpretation of my argument, that in this case, I would say the court abused its discretion because it decided simply that you have to put on some prior evidence of mental health being an issue. And they just adopted pretty much the state's argument that, well, we haven't heard anything about mental health in this case, and so why should you grant this? And certainly at that point, the court could have asked further questions. But my interpretation of how I've argued is that the court's decision on this essentially said, well, in order to bring this forward, you need to have done something prior in this case to put your mental health at issue. And the only ways that can really happen is through a request for a competency evaluation or a mental disease or defect defense. And there are myriad reasons why an attorney would not pursue those, largely because the bars for those are very, very high, and rightly so, because they're constitutionally protected. But this mechanism provides something that, despite the fact that she probably was competent and that she probably didn't have a mental disease or defect defense, there's still something about her mental illness that, I mean, she even, discussed it in her allocution, that perhaps if she had an evaluation might give the court a better idea of whether or not prison would be the best setting for her, or if she needed treatment in order to get to a place where she can serve her sentence in a prison setting.
So what's the remedy? I'm curious of if we agree with you, what would happen?
And I would say that the remedy is fairly narrow. What we're asking for would be a remand for her to have the mental health evaluation, and really just to have the court have that available for them when making the sentencing determination. I'm not saying that she is going to have the mitigated sentence, or that the court is going to decide that she needs to be in a treatment facility instead of prison, but it provides the court with the opportunity to consider that information. And so the request would be for her to have that mental health evaluation in a new sentencing hearing. As far, I think unless there are any further questions on the competency issue, I would move on to the hearsay issue, which again is an abuse of discretion standard of review. In this case, there were several pieces of hearsay that the state requested be introduced at trial from various witnesses. regarding things that Joel had told them that Tria had said or had played voicemails that Tria had left for him. And the court, in evaluating this, found that the necessity exception applied. Of the 31 hearsay exceptions, that's the one that the state relied on. And I'll be honest, as I was walking through this case and working on it, I was brought back to law school and learning all about hearsay all over again, which is a very difficult thing. And so I understand that the court had difficulty with this. It was a very confusing discussion, but this court has set forth the evaluation of a necessity exception. And so you have to find that the declarant is unavailable as a witness, that the matter described was recently perceived and was made while the memory is fresh, and that it was made in circumstances as to show it was in good faith and no incentive to falsify or to distort. Again, my argument is that the court abuses discretion as a matter of law in this case because they failed to follow those steps. Because they fundamentally misunderstood who the declarant in the situation was. And so instead of evaluating the question under whether or not Joel himself was making these statements with an intent to falsify or distort, the court looked at the person who was listening to it, the various witnesses, and said, well, of course they have no reason to falsify or distort, or they're obviously not acting in bad faith because why would they? And the question that muddles the question, because the purpose of a hearsay, the purpose of a prohibition on hearsay is because you cannot judge the credibility of the person who made the statement. So in this case, we weren't worried about the credibility of the witnesses because they were going to testify. Their credibility was going to be evaluated. The question is whether or not the statements as made by Joel or Tria were credible. And so in misframing how the issue was evaluated, the court abused its discretion. And so I would request that this be reversed because of that error. We maintain that it's reversible and that the state cannot show that there's a reasonable probability that the outcome of the trial would be different without these hearsay statements, simply because of the nature of the state's case and its heavy reliance on circumstantial evidence going to the relationship between Joel and Tria.
Counsel?
Yes.
I think there were a slurry of different statements that maybe you're describing under the hearsay exception, but were those really offered for the truth of the matter asserted, or were they offered to establish more motive, state of mind?
The way that I would recall this being argued is that they were offered to show that the relationship between Tria and Joel was tumultuous, that they had a bad relationship, which I believe that the statements are offered to show the truth of that matter asserted. That if that's the matter that they are asserting, they are offered to show the truth of that.
Yeah, maybe it's hard without going through a specific declaration in question, but if the statement was, about what he did or didn't do with their daughter, my understanding was that wasn't really offered to show whether or not he in fact, did those things or didn't do those things with his daughter, but instead to demonstrate how tumultuous or how rocky the relationship was.
Yes, I would say that is how they were evaluated. I guess my response would be, I don't think that anybody, there was any challenge to the fact that they were actually hearsay statements. And so I wouldn't, obviously this court can reach that question, but that was not something that was ever challenged is that, I mean, everybody agreed that these were hearsay statements. And so I don't think that I briefed that issue or even discussed it, simply because it was just something accepted by all the parties below. If there are no further questions, I would just ask this court reverse Tria's convictions based on the inadmissible evidence of this case, or in the alternative, reverse for her to receive a mental health evaluation and a new sentencing hearing.
I don't see any further questions. Thank you, Ms. Gunning. Mr. Simpson?
May it please the court. Good afternoon, Your Honors. I'd first like to address the hearsay challenge in this case, and then I'll probably briefly touch on the mental health evaluation issue, and I'll likely also submit the prior bad acts evidence issue to the court on the briefs. But concerning the hearsay issue, I think it's first important to note that what's actually before the court and what isn't before the court. And below, Evans only moved to exclude Wales' statements as hearsay. She did not raise a hearsay objection to her own statements, and so that issue was never considered or addressed below specifically. But in any event, whether the challenge is preserved or not, if this court reaches the issue, the district court properly admitted both Wales and Evans' statements under the necessity exception in this case. The evidence in this case shows that the statements were sufficiently recent and clearly recalled. In particular, the statements, Wales' statements were clearly inspired by Evans' ongoing conduct. Wales' statement to Herman that, quote, "I'm afraid she's going to shoot me," occurred immediately after Wales had just ended a call with Evans, a call that Herman testified had immediately changed Wales' demeanor and left him in a poor mood the rest of the day. We know that Wales' statement to Hadel that, quote, "If there's ever a time that I'm not around here anymore, the bitch shot and killed me," that statement was a response to Wales trying to ignore Evans' repeated calls. Wales' statement to Razzo that he had just gotten in a fight with Evans at his mom's house and she had left was obviously self-evidently inspired by the fight that had just occurred. So, in this situation, these are statements that are obviously almost even contemporaneously, even though that's not required under the necessity exception here, responses to an incident that just happened. Regarding Evans' threats, there's also evidence that these threats left in voicemails were inspired by Wales' failure to respond to her texting calls. McClellan and Hadel testified to a voice message she left where she said, "If you don't answer your phone and you don't want to be with me, I will end up shooting you." I mean, that's evidence right there that, again, the statement that at issue was inspired by the event immediately preceding, and really the nature of the voicemail messages captures the contemporaneousness of everything.
Mr. Simpson,
Mhm.
what would you respond to Ms. Gunning's statement that the trial court misunderstood who the declarant was?
Sure. I don't think there's any dispute that the court's comments show it put some focus on whether the declarant, sort of the temporal relationship between the declarant hearing the message and when it was left. But again, I don't think that necessarily means the district court didn't also consider the correct factor. And obviously the evidence in this case supports that these statements were admissible as recently perceived and clearly recalled. We're returning to the issue of incentive to falsify or distort.
Mr. Simpson, do we have any, the whole notion of recently perceived, can you give us any guidance on what that means? Are there any contours to that concept? What is recently perceived? Because in some of these, there's different time gaps. Some of them are kind of contemporaneous with what's happening. Other times it's not. What's your best or what's your argument that these satisfy that kind of concern about recently perceived, what the recent perception?
I would just direct the court to its analysis that it applied in State v. CCAT, a case cited in the state's brief. There, the hearsay statements admitted under the necessity exception were the victim's recitation of the defendant's threats, statements she made to coworkers. And the evidence in that case was unclear exactly when the original threat was given and when the statements were repeated. But the court was able to determine that that even though they were unable to pinpoint a specific time frame, that the evidence confined things to a period of roughly 4 months, and that even a threat as old as 4 months was adequate to meet the requirements of the necessity exception. And so I think, again, the evidence in this case shows that far less than 4 months occurred between the event inspiring the statement and the statement itself. But again, I would say that clearly that same analysis would cover any of the statements at issue in this case. The custody dispute and whether it created any incentive to falsify or distort, I would note that none of Wales' statements and Evans' statements to Sydney regarding her scheme to murder Wales and solicitation to murder Wales, none of those statements involved individuals who participated in the custody proceeding. Those statements were essentially to friends, coworkers, and also those statements, none of those statements, apart from maybe one voice message that was testified to in the case, had anything to do with the child. It also, regarding Evans' statement specifically, if anything, an ongoing custody dispute would disincentivize a reasonable person to make the statement she made. And ultimately, again, pointing to CCAP and the analysis employed there, the fact and manner of the victim's death in this case tends to support the reliability of these statements. So on this issue, I would again ask that the court affirm the district court's admission of the evidence. But even if the court were to determine that the admission was erroneous, I would just argue that there's no reversible error here, because there's no reasonable probability that any of this evidence impacted the jury's verdict. Here,
why wouldn't there be? Just in the sense of, didn't the hearsay evidence really give a context for what was happening between these two? The state's theory that it was a pretty obsessive kind of compulsive behavior that Ms. Evans had towards the victim. And all of that, a lot of that was established through this evidence. What else is left after the absence of that?
Sure. Well, I think there's abundant and compelling independent evidence in this case that incriminated Evans. The evidence showed that Evans owned a gun of the same type used to murder Wales. She had wrote a note with Wales' personal information on it that bore her handwriting and her thumbprint, and that was found in a co-defendant's home. Texts between Evans and her co-defendants leading up to the murder showed that she had discussed a desire for, quote, relief, that she was hoping to, quote, take care of something, and that Evans' co-defendant was planning to travel to her house that evening of the murder. GPS evidence and evidence from camera footage across from Evans' home in this case showed that Evans' co-defendant traveled to Evans' house the night of the murder, picked someone up from Evans' home. That car then traveled to a gas station. It then traveled to the scene where the crime was committed, and then traveled back to Evans' home. Additionally, Wales, the neighbor next to the home where the crime was committed, saw a woman outside the home before a fire erupted. Investigators discovered that fire was started with gasoline, and a gas can was ultimately found in the trunk of the co-defendant's car. You have information that location information from the phones that placed both Wales' phone and Evans near in the same location near Lake Perry after the murder. You have shoes that were first spotted in Evans' home, later discovered in the co-defendant's chimenea, alongside shoes that had blood spatter on them. There was additional information that the jury heard of another romantic partner of Evans, that Evans had solicited him to kill the victim several times. You additionally had Evans' ex-husband testify that when he visited Evans after the murder and asked her if she killed Wales, she, instead of altogether denying that she killed Wales, smiled and said, "My phone and my car were at home." And finally, there was a handwritten note to the victim's mother where Evans apologized, and she asked for forgiveness for causing the loss of the son. So all this independent evidence was sufficiently incriminating that there's no reasonable probability that the hearsay evidence or the hearsay statements in this case led to an improper verdict. And turning to the mental health evaluation issue, to Justice Rosen's point, it's the state's position that if what the court did here was an abuse of discretion, then contrary to the court's case law, there's essentially no circumstance where a court has discretion to deny a mental health evaluation. Because again, all that occurred in this case was a motion was filed, the motion requested an evaluation, it cited the language of the statute, and then when later given an opportunity to substantiate the motion by offering any sort of evidence or arguments that might give the court a reason to believe Evans had a mental condition that might require alternative placement, defense counsel essentially said, "We have nothing to add." So really, the court was left with no basis to grant an evaluation, even if to basically grant its or exercise its discretion here. So if the court has no further questions, I would just ask that the court affirm Evans' convictions and sentences in this case.
I don't see any additional questions. Ms. Gunning, you reserve 3 minutes for rebuttal.
Regarding the request for evaluation, I would just say that I think that case law on this particular statute is scarce. It's sort of my experience and opinions thus far, is that most attorneys kind of weren't really aware of it or utilizing it prior to the opinion coming out in Kaler. And so I don't think that it really has been set forth exactly what needs to be put forward by defense counsel who is requesting this. But I don't think that what the court said here is that you've never put on anything of mental health concerns before. Well, obviously there is something, otherwise the attorney wouldn't ask for it. I guess I would say the harm in granting that, I don't know why you wouldn't just simply grant it, except for if you're just ready to move forward with a hard 50 sentence. And so I don't think that the statute requires that the mental health be made an issue earlier in the case. I think that's the crux of the question, is what the court said in this case is you haven't made it an issue. And that's why the argument is that the court made an error of law, because the statute does not require that. She made it an issue by filing the motion, and that should be sufficient. Or if the court wants to deny it on a different ground, to say, well, I don't see that you've put forth anything that would show me the mental health as a problem here, then that would be a ground, but that's not what the court found in this case. To opposing counsel's note that in this case, the question is only as to whale statements and not Tria's. I would say I think that in this case, it's pretty clear that everybody expected Tria to testify. That was the basis of the opening argument in the case. And my inclination is that it was a surprise to everyone in the courtroom when she chose to exercise her Fifth Amendment right. And so the state never asked that these would be hearsay statements that they would consider. The state requested Joel's statements and requested to have a finding on hearsay for those statements. And that's why there is this limitation, I think, because everybody expected that Tria would testify.
Well, let me understand. Are you objecting to Tria's testimony based upon there was no necessity hearsay exception? Or is that what you're saying?
I'm just responding to opposing counsel's point that the Tria's statements are not part of this. To the extent that Tria's statements came up, it was statements, I believe, to Jody. And so Joni. And so there wasn't really a challenge to her statements, but I think that the reason is because not because they just wanted those statements to come in without opposition, but rather that they planned to have her testify, that she had planned to testify. And so I think that the only thing at issue in the brief is particularly getting to her statements and whether or not they should be excluded would be the statements that were sort of double hearsay types of questions. That's why there's that limitation. And I don't think that the failure to object to those hearsay statements should prevent this court from reaching whether or not Joel's statements were properly introduced as hearsay. And unless there are no further questions, we would say that the admission of those hearsay statements based on an error of law cannot be proved to have no reasonable probability that they had an effect on the outcome of the case. And this court should reverse Tria's convictions or remand for a mental health evaluation to determine sentencing mitigation questions.
Doesn't appear to be any other questions, so I'll thank both counsel for your arguments today. The court will take this appeal under advisement. We'll now turn to the second case on the afternoon docket. Mr. Shima, do you please call the remaining case? Or I will.
Sorry, Your Honor. I was trying to get everybody set up.
Sorry.
May it please the court. The second case for the 1:30 p.m. docket is appeal number 13682 in the matter of Roy T. Artman, original action and attorney discipline. The disciplinary administrator has reserved 2 minutes rebuttal time. Your Honor, we are ready to proceed.
Thank you, Mr. Shima. Will counsel please state your appearances?
May it please the court, Tom Stratton appearing for the Office of Disciplinary Administrator, present and ready for argument.
Madam Chief Justice, Your Honors, may it please the court. Mr. Artman appears in person by John Ambrosio via circular.
Thank you, counsel. Mr. Stratton, you may proceed.
Thank you. The respondent, Roy Artman, was admitted to practice in Kansas 29 years ago. He was practicing in Topeka as counsel for an insurance group at the time of his temporary suspension, November 27, 2019. He was temporarily suspended because 2 weeks earlier, he was convicted in Shawnee County District Court of a level 6 felony, leaving the scene of an accident involving death. The conviction was based on Mr. Artman's actions of 3 years before, on November 4, 2016, when he was driving home from Lawrence to Topeka on I-70. He passed through the East Topeka toll booth a little after 11 p.m. A few minutes later, he struck two people who were changing a tire on a car parked in the median lane. One person was not injured, but the other AE was killed. Mr. Artman did not stop at the scene, but he immediately pulled off I-70 at the next exit, Rice Road. He inspected his vehicle, found damage he considered minimal, continued to his home in central Topeka without getting back on I-70, without revisiting the scene of the accident or notifying authorities of his involvement. The disciplinary administrator's office sought disbarment retroactive to the date of the temporary suspension, and that was the hearing panel's determination. We contend that disbarment is necessary based on the seriousness of Mr. Artman's actions, which included his actions resulting in the accident and also deception as it pertains to events surrounding the action. Deception and dishonest or selfish motive were among the aggravating factors identified in the final hearing report. In accordance with ABA Standard 5.11, those aggravating standards prompted the hearing panel's recommendation of the ultimate sanction of disbarment. Recognizing the court is conversant with the facts, I'll review the respondent's deceitful actions in a highly summarized form. Where applicable, we'll tie them to the rules of professional conduct violations that were found by the hearing panel. First, it may not rise to the level of the other instances of deception, but there is mention in AE's father's statement in the record of the anguish he experienced, knowing that part of the explanation why his son's life was lost was Mr. Artman's distraction with presets on his truck radio. This mention by AE's father suggests the need to discuss it now. Mr. Artman said that being distracted by setting radio presets was a contributing cause of the accident. One of the times he said it was in his January 13, 2020 response and explanation provided to the disciplinary administrator. As we now know, because it was conceded by Mr. Artman at the hearing and determined by the hearing panel, setting radio presets had ceased to be a contributing cause prior to the accident. The suggestion of a distraction was in itself a distraction. Following up on the questioning of Mr. Artman by the hearing panel presiding officer, I'll suggest that the logical reason why it would be mentioned in Mr. Artman's response and explanation when all mention of his use of alcohol on the day of the accident was omitted from that document was that it was a feint, a deflection from other possibly more important factors. Second instance suggesting deceit was Mr. Artman's testimony that he never saw the stranded vehicle or the pedestrians before or after the accident. That was found to lack credibility by the hearing panel. The third, Mr. Artman's account of what he believed he hit an animal such as a bird or a construction sign or cone was also found to lack credibility by the hearing panel. Fourth, failing to return to the scene of the accident was a criminal act that was determined to be dishonest conduct in violation of KRPC 8.4b. Fifth, finally, Mr. Artman's failure to admit to drinking margaritas at dinner on the Friday evening of the accident when he was twice questioned about it the following Monday by Trooper Simone was determined to be misleading, which Mr. Artman conceded and the hearing panel found was conduct involving dishonesty, fraud, deceit, or misrepresentation in violation of KRPC 8.4c and conduct prejudicial to the administration of justice in violation of KRPC 8.4d. The explanation for his failure to disclose the evening drinks given at hearing, that he was distraught because he had just learned he had caused a death, was not supported by a review of the video of the interview, which showed he was informed of the death after he had addressed the drinks issue with Trooper Simone. The hearing panel determined the duty violated by Mr. Artman was to the public to maintain his personal integrity. For Mr. Artman's mental state, it determined that he knowingly and intentionally violated his duty. The injury was determined to be the ultimate one, taking of a life, and also the loss of a shared future by AE's parents, sons, and friends. The aggravating and mitigating circumstances found by the hearing panel were aggravating, dishonest or selfish motive, submission of false evidence, false statements, or other deceptive practices during the disciplinary process, vulnerability of the victim, substantial experience in the practice of law, and illegal conduct, including that involving the use of controlled substances. The mitigating absence of prior disciplinary record, the present and past attitude of the attorney as shown by his cooperation during the hearing and his full and free acknowledgement of the transgressions, with the one exception being his reason for omitting reference to drinking at dinner when responding to Trooper Simone. The previous good character and reputation in the community, including any letters from clients, friends, and lawyers in support of the character and general reputation of the attorney, imposition of other penalties and sanctions, and remorse. The majority of the evidence introduced by respondent in mitigation and considered by the hearing panel were letters supporting him written by fellow members of the bar. They were obviously sincere and the result of Mr. Artman's consistent professional fair dealings with the writers. Many were written by lawyers I know and respect. However, none of the letter writers were present on the night of November 4, 2016, or for the following events in this case that have been discussed. There's a quote in the ABA standards book that says simply, a lawyer is a professional 24 hours a day, not 8 hours, 5 days a week. And that's a very demanding standard. It can chafe. It has the potential to cause anguish that we may not know whether we can stand sometimes, but we have to live with the fact that the expectation of professionalism resides in us all the time without exception. To complete the summary of the hearing panel's considerations, I should mention that in addition to standard 5.11 related to disbarment, they considered the applicability of 5.12 for the appropriateness of suspension. This is a tragic case. The accident took the life of AE and has forever changed the course of the lives of AE's children and parents. It has caused an interruption of the career of a member of the bar, Mr. Artman, who had earned the respect of his peers. And now it's our obligation to ask that this career interruption caused by the temporary suspension that remains in effect become a disbarment retroactive to the date of the suspension. To ask for any sanction less than disbarment under the circumstances of this case, which the hearing panel determined justified the applicability of ABA Standard 5.11, would be insufficient recognition of the extent to which the lawyer's duty to the public to maintain personal integrity was violated and would fall short of maintaining the trust and confidence the public places in a lawyer. And that concludes my remarks. I'd be happy to answer any questions.
Are there any questions? Thank you, Mr. Stratton. Mr. Ambrosio?
Madam Chief Justice, Your Honors, may it please the court. This may be the saddest case that I have worked on since I started doing disciplinary work. First, let me start by telling you the factual findings by the panel and the rules violations are accurate and correct, and we don't have any fight with that, hence why we didn't take any exceptions. This was a tragedy for the young man's family, as my colleague has just indicated. It was a tragedy to his children, to everybody involved. It's also a tragedy to Roy. If the family members are listening in, as I did at the hearing, I express my sorrow for your loss because I think it's important as a member of the bar that I do so in performing my duty. But this has also been a tragedy to Roy, a good lawyer, well respected by people on both sides of the work comp bar and personal injury bar. He was well liked and well respected, hence the letters that my colleague, Mr. Stratton, talked about. He has a clean record, didn't have any problems till this tragic act occurred. The question obviously for you as a court is what discipline should be meted out? I'm asking for an indefinite suspension. We understand what should have occurred during this case. He can never, he meaning my client, can never take back what he did that night. I'll bet you $1 million that he would never again text or use his radio to set presets, even in his enjoyment of the new car. He didn't realize, whether the panel believed it or not, what he had hit and what had caused this terrible accident. He left the area, went home, saw a slight problem with his car, and was totally surprised when law enforcement showed up at his workplace on that day, 2 days after the hearing. Now, I'm a cynical lawyer, maybe one of the most cynical who appear in front of you. A cop shows up at my doorstep and asks any questions. I refuse to answer it and shut the door in his face, whether he showed up here at the law firm or at my house. But that's because of the nature of the work that I carried on for almost 50 years. My client is a different type person. He answered the questions. Admittedly, he was less than candid for whatever reason, about the extra alcohol that he consumed in the evening. He consumed a couple of beers, 2 to 3 beers with his son at lunch, and then a series of 4 or 5 hours went by, and when his daughter-in-law came out, they went out again for dinner, and he had a margarita, a large margarita, and part of another. Alcohol was never brought up in the criminal case. What my client did was the smart thing after he was talked to by the trooper. He immediately called a bunch of lawyers and they sent him to our office, not for representation by me, but by representation by Kathleen Ambrosio. She represented him on the case for about 2 years before she died, and then we transferred the case to somebody else. There's a little of me that wants to say maybe the result before the jury would have been different if Kathleen was still trying the case, and that is not in any way to denigrate my good friend Tom Lemon, who took over the case. What do we do about this situation? Indefinite suspension that I'm arguing for, and my colleague is arguing for a disbarment, yet back to the original suspension that took place November 27 of 2019. Let's also not forget that the accident, the serious death that occurred happened a couple of years before the jury returned the verdict. So my client, as is the family of the victims, has been living with this problem for all those years. Indefinite suspension from when your decision comes out 3-4 Fridays from now means he can't apply again for 3 years. Disbarment, the way my colleague, Mr. Stratton, wants it, back to 2019, although he can't apply for 5 years, would put him at the same place as an indefinite suspension. The reason I'm asking for an indefinite suspension in addition is because my client works and is still working for the same outfit that he was working for when this terrible tragedy occurred. He's not working as a lawyer. They're using him as a claims rep to be the boss of, to manage the other 5 or 6 clean representations. They've kept him there, and it is our belief that if he is indefinitely suspended, they will allow him to continue to do his work in a non-lawyer capacity, not seeing claimants, not seeing clients, and to continue work, albeit at a lesser salary. If he's disbarred, I'm not sure the same situation will occur. I'm going to be short and to the point because my client, with your permission, would like to address you. This is a good man who did a terrible thing. This is a good man who committed a terrible act, and then because of whether my colleagues in the panel believe it or not, because of nervousness, because of what he was feeling during the course of his involvement from the police, left out what had occurred, the second drink and a half that occurred at night. Alcohol was not involved in this accident. We ask that you have some type of mercy and give him an indefinite suspension. And if you want a reinstatement hearing, we are agreeable to that. We would suggest that. Now, without any further ado, I'd like my client to address the court.
Good afternoon, Your Honors. The events that occurred on the night of November 4th, 2016 changed my life dramatically and the lives of many others, I realize. For the young man who passed, for his mother, his father, for his children, for his family, and other friends, life will never be the same. For that, I am so very sorry. I humbly apologize to those that may be listening. Being a parent myself and a grandparent as well, I can't even begin to imagine the loss and the suffering that they have had to endure because of this. My heartfelt sympathies do go out to the family. And I regret that my action and my lack of good judgment that evening has caused so much sorrow and loss to all involved. I can tell you that not a day goes by that I don't think about that night. And the numerous what if I'd only done this, or what if I'd only done that goes through my mind on a daily basis, thinking that things would be different somehow. But unfortunately in life, we don't get the opportunity to do a rewind or a do-over. And I simply have to live with the mistakes that I've made. I have let down so many people and disappointed so many people. To them, I say I'm sorry as well. My children, my family, my friends, my coworkers, my colleagues, the members of the bar. For that, I'm very saddened, I'm ashamed, and I'm sorry for my actions. But that night, I did make several mistakes, many mistakes. I allowed the giddiness of having a new vehicle to divert my attention and focus from being that of a good driver. Messing with the seats, messing with the dash lights, the presets on the radio, all those things are things I should have not been doing while operating that vehicle. That should have been something I should have done at a different time when I was parked safely in my driveway. There's no doubt that I was a distracted driver. I was a bad driver that night, and it cost someone dearly. After having made contact with, at that time, an unknown object, I failed to determine exactly what transpired. Instead, I pulled over within a short distance. There was an exit that came up. I got out and inspected my vehicle, and all I found was very minimal damage to the mirror of my vehicle. Rather than going back like I should have and exercise a good judgment, I made an assumption that was wrong, thinking that I either struck a bird, an animal of some kind, or maybe even a construction siren, cone, or other device. Looking back now, I wish I would have done the right thing and gone back and made a thorough inspection and determined exactly what I came into contact. I wish I could take those moments in time back, because I haven't. So much things have changed. When speaking with the trooper the following Monday about the accident, it was never my intent to be deceitful or dishonest with him. I was simply trying to assist him with his investigation of what I considered and perceived to be a terrible, tragic accident. I wasn't thinking clearly, and I could barely hold a thought in my head at the time. What I do remember thinking was, oh my gosh, this person has passed, and what impact it would have on his young children. I regret any confusion or distress that I may have caused any of the parties involved in this regard. Again, it was not my intent to be deceitful or dishonest. I was trying to be helpful and as cooperative as possible. Had I wanted to conceal information from the officer, I could have simply invoked my rights and not answered any of his questions. It's difficult to understand in my mind and explain how your mind works at times, but I know I was not trying to be deceitful or dishonest, and I wasn't clear thinking at that time. I was very distraught, and again, tried to be as helpful and as cooperative as I could have. As Mr. Stratton has noted, I was granted the privilege to practice law in this state in October of 1991. Since that time, I've taken great pride in how I conducted myself as a lawyer, and I've always tried to do the right thing and do it the right way. Always wanted to be a good lawyer. Over the years, I felt that I've done that, as evidenced by the letters that have been submitted on my behalf by various members of the bar. Most of them have been adverse counsel to me in the many cases I've tried over the years. As I sit here today, and I will tell you, it's very defeating and disheartening that I've allowed a few moments in time to undo what I spent years building. I'm asking the court to grant me an opportunity for redemption. I'm asking for a second chance to be that good lawyer again. I pray for a suspension that be imposed, and I'm given the opportunity for reinstatement in the future. Thank you.
Any questions? Anything further, Mr. Ambrosio or Mr. Artman?
No, Madam Chief Justice.
Mr. Stratton, you reserve 2 minutes. Mr. Stratton, you're still muted.
I believe what I want to say is that you heard from Mr. Artman a number of facts that were addressed at the hearing panel, at the hearing, and the hearing panel was in a good position to assess Mr. Artman's demeanor when he was testifying and to assess all of the evidence, which now is before you, and I realize you have an opportunity to review it as well. We support the hearing panel's determination rather than to address individual instances that Mr. Artman talked about. I think I'll just address one, as I did with the hearing panel, which is that instance where you know you've hit something, and as it came out, you know it might be a person, and instead of pulling over immediately, you drive on. And that's the one that is stuck for me, and so that's the one that I'll leave you with.
Any questions? Thank you to both counsel and to Mr. Artman for your statements. The court will take this matter under advisement. This adjourns our docket.